Welcome back to the course, Protecting the Legal Rights of Artists and Designers. I am Jonathan Politi, and we are working our way through materials covering the legal system and dispute resolution. And in this segment, we will be covering the court process and what steps are taken in pursuing a lawsuit. Now, typically when people think about the law, they focus on courts and lawsuits and attorneys. Those aren't the only aspects of the law, but they matter. They do potentially affect businesses, and they are worth understanding what they are worth. By now, you should have completed the Legal Eagle assignment on civil lawsuits and also the Ohio State Bar Association assignment on Do You Need a Lawyer? These should provide some idea of what happens in a lawsuit and what an attorney is and does. They can fit into how you want to resolve a dispute or disagreement. Using the legal system can be daunting, and I often advise my clients to avoid lawsuits for many reasons. The costs financially can add up, and it can be expensive. The costs and disruption of business and personal lives can take a toll. The potential losses to brand and reputation can be irreparable. Prevention and planning, customer service and communications, contracts and clarity, setting expectations and following through can go a long way to avoiding problems. Making sure that people are safe, aren't harmed by your business, is important. Compliance with regulations and standards of the industry can provide protection to customers, to clients, and to the business. And there's value to following the rules. They're there for a reason. But that being said, we're going to cover civil and criminal lawsuits. A brief explanation of civil and criminal cases. They're similar but different. Both types of cases are physically held in the same courthouses in front of the same judges and justices. There aren't separate courts for the two. Judges hear both civil and criminal. The stakeholders or parties are different. Criminal cases are prosecuted by the government, and civil cases are prosecuted by and on behalf of individuals. Enforcement of law is another different aspect because criminal and civil laws are two different kinds of laws. There are differences between the processes and procedures and protections in civil and criminal cases. The goals of the systems are different and the outcomes are different. Civil cases end up with some potentially being held liable. Criminal cases end up with someone potentially being held guilty. The procedures are different. Here's a side-by-side comparison of the basics of civil and criminal procedure. Who can bring a lawsuit? For civil cases, individuals or entities such as corporations are known as plaintiffs and file the lawsuit with the court to enforce their rights. Their rights have been violated, so they have standing to bring a lawsuit. Contrast that with criminal cases, where the government representing the people, known as the prosecutor or district attorney, files the lawsuit. Each is respectively responsible for moving the cases through the court processes, telling the stories, and laying out a narrative that shows that the law and the people's rights were violated. Presentation of evidence is the responsibility of the parties that file the lawsuits. The standards of proof are different. For civil cases, the burden of proof is the preponderance of the evidence standard. More likely than not that the evidence supports the narrative that's being told and that the story is credible and believable. That's roughly 51% as a standard, although there's no exact metric for weighing the evidence. For criminal cases, the burden of proof is much higher. It's the beyond a reasonable doubt standard. Reasonable persons would have almost certainty that the narrative being told is believable. That's roughly a 99% standard, although again there's no exact metric for weighing evidence. There are rules, but no mathematical formula defines the value of witness testimony or other evidence introduced to convince the court. The standard is higher for criminal cases because the stakes are higher. Consequences can be fines to incarceration to death as opposed to money damages or injunctions in a civil case. And the terminology for the outcome of the case is different. For civil cases, it's liability, while in criminal cases, it's guilt. Don't get those confused. Now, it's possible to have both a civil lawsuit and a criminal lawsuit for the same set of actions. Enforcement of the law by a prosecutor on behalf of society and enforcement of the law by individuals for their rights being violated. The same events under both sets of laws and procedures. But understand that criminal laws and civil laws may be related, but they are still different. Depending on the law that's being enforced and the type of case that's being heard, the outcomes can be different. The way the laws are defined will dictate how they are enforced and what process applies. Even if they have the same term or words used, they can be defined differently for criminal and civil cases. The textbook example is assault and battery. The same words mean different things. Definitions may not be shared across the different laws. The intent of the lawmakers may be different, even if they may sound like they are the same. Pay attention to the definitions within the specific laws that apply, so that there's no misunderstanding and no mistaken expectations. Every law has its set of expectations. It's a checklist of elements that need to be satisfied in order to apply to a lawsuit. Apply the facts to the law in order to prove a case. So, the example of assault and battery. A person is attacked as he is walking down the street. It can be both civil assault and battery and criminal assault and battery. Civil wrongdoings are sometimes called torts or personal injuries. For a civil case, assault is an intentional act, not accidental, that creates a reasonable apprehension or belief that there will be an immediate harmful or offensive contact. And battery is the intentional harmful or offensive contact. For a criminal case, assault is the attempt to injure another, and battery is the act that results in the injury of another. Note the differences. For the civil lawsuit, the plaintiff has to believe that there will be harmful contact. If the person is unaware, then there will be no civil assault. However, criminal assault has nothing to do with the belief of the victim. If the defendant has attempted to injure, that is what matters. The same term, but with different requirements because the laws are different. For civil lawsuits, the plaintiff enforces. For criminal lawsuits, the prosecutor enforces. The outcome for civil cases is typically restitution, putting the wronged person back to where they were through restitution and compensation. That's money. The outcome for criminal cases is punishment, deterrence, and reform, usually weighing more on the punishment. Okay, we're going to focus more on the civil side of lawsuits. Many times I get people that call me or reach out to me or come by my office and they bang their hands on the table and they say, I want justice. And I talk with them and I try and figure out what happened and I try to come up with options. And during the course of the conversation we figure out if they have a good case or not. Is there a right that's been violated? Do they have proof? Is it credible? And even if we figure out that they have a good case, that doesn't mean that suing is the best option. A lot of times people say they want justice, and I tell them, justice will cost you this much. Going to court takes time and costs money and resources. So I want you to understand some of the process. You had watched the Legal Eagle video explanation for civil lawsuits, which is good, but he tends to use legalese, which can be confusing. Some of his visuals are helpful, but some are not. He tries to give you a sense of the different stages. He talks about civil lawsuits and basic process and timing, but there's a lot of detail and legal jargon that he glazes over. Lots and lots. Don't get me wrong, it's good stuff, or I wouldn't have shared it with you. It's a good starting place, but it needs more context. There are 3 main stages to a lawsuit, and there are many small steps in the process. This may seem too simple, but pay attention. 3 main stages: pre-trial, trial, and post-trial. Pre-trial, trial, and post-trial. What happens leading up to going to court, the actual presentation of the case in court, and what happens after going through the trial. There's this visual that I like to use in class. I like to use this visual and have the students get handouts, and they can follow along and write on the handout. I've shared the handout on Go Studio for you to have, and you're free to follow along as I go through the stages. I realize that some of you aren't able to print this out, so I won't make this an assignment, but I like this because it lays out the process in a more connected way. I compare it to the game Chutes and Ladders, which some of you may be familiar with, and I had someone coin it Chutes and Lawyers years ago. It's meant to be a fun activity. Just remember, being sued is horrible even if you win. So this may be fun, but going to court, not so much. Alright, let's take a look at it. Page 1. There's a process to going to court, starting with someone feeling they've been wronged and their rights have been violated. They say, "I want justice," and bang their hand on the desk or the table. And after talking with an attorney and deciding that this would be the best option, a document called a complaint is filed with the court, which starts the court process. The person who's bringing the cause of action, the lawsuit, is called a plaintiff. A case is opened up at the court, and the clerk's office sends out a notice, a summons, to the person named as the defendant. Everyone is entitled to due process of law, to have a day in court, but in order for that to happen, they have to be aware that the lawsuit's been filed. Once there's notice, the clock starts ticking. Typically, this is done via certified mail. A green card goes out along with notice in the mail to the defendant's address, and someone signs for that piece of mail. That becomes the proof that it was delivered and the defendant got notice. Due process of law. Now, it doesn't have to be the defendant that signs for that piece of mail. It could be anyone who is of legal age that is at that address. That's sufficient for there to be notice. So the bad scenario is where the defendant's roommate signs for the certified mail and never tells him or her until 3 weeks later, "Oh, is this important?" And the whole time the case is moving forward and there's a deadline to respond to. Now, if certified mail doesn't work, where no one signs for the mail, then the clock doesn't start ticking. Oh, and for those of you that say, "Just don't sign for the mail, tell the mailman you don't want it," then the mailman will mark it as refused and will go back to the court. And then there'll be other options. And yeah, there are other options. Another option is to have the summons issued by a sheriff's deputy on behalf of the court. That could be at home, or a place of work, or a known place where the defendant might be. That then would be the proof of notice, and the defendant would get a chance to respond under due process of law. Or another option is to have a private process server, someone who is paid to take the notice to the defendant and then signs an affidavit with the court swearing that they provided notice to the defendant, and that would be proof of the notice, and the defendant would get a chance to respond. Or, if all else fails, service by publication, putting notice in a newspaper with a large enough circulation that it is assumed the defendant would see it, and now even certain kinds of social media are acceptable to serve as notice by publication. Once there's been proper service of process, the defendant is put on notice that a lawsuit has been filed. The defendant has 3 main options at this point. The first option is to file a motion to dismiss. The argument is that the court doesn't have jurisdiction to hear the case, that it doesn't have authority. It's the wrong person. Maybe the wrong person named in the lawsuit because they really should have sued the business instead of the individual who owns it. Or there's some confusion in the name, junior instead of senior. Or maybe it's the wrong type of court. It needs to be a federal court or a specialty court or a state court. Or maybe it's not really a law that's been violated. Nothing is there for the court to enforce. Or maybe too much time has passed and the deadline to file, the statute of limitations, has passed. You snooze, you lose. The plaintiff gets a copy of the motion that is filed with the court and gets a chance to respond to it. Maybe the court decides to have a hearing with the judge to decide if the case should be dismissed, or maybe there's not a hearing and the judge makes a decision based on the pleadings, the motion. If the judge accepts the motion to dismiss, then the lawsuit is dismissed. The case goes away and goes no further in the court. It's done. However, the judge can also deny the motion, which would mean that the case would go forward. Option 2. Defendant can file an answer to the complaint that was filed and can even countersue. The answer will respond directly to the allegations and statements that were made by the plaintiff in the complaint. It affirms the statements that the plaintiff makes that the parties agree to, and it denies other statements that are in contention. Anything not denied is deemed admitted, so the defendant wants to deny the allegations that would benefit the plaintiff and hurt the defendant. And the countersuit or counterclaim can be a lawsuit by the defendant against the plaintiff for damages arising out of actions that are subject of or related to the lawsuit. You're suing me, I'm suing you. And the plaintiff would get time to respond to that as well. A cross-claim can happen when there are multiple defendants. The defendants can sue each other in addition to suing the plaintiff, and those co-defendants would get to answer those cross-claims. And a third-party claim is when there is someone that should have been part of the lawsuit, a necessary party, in order for there to be justice, and that person is added. And those third-party defendants can answer and countersue. So, under option 2, it could be answer and counterclaims. Just so you know, you can do both options 1 and 2 together. Ask for the case to be dismissed, and if the court doesn't agree with the dismissal and grant it, then it will review the answer and possible counterclaims. That would move the parties forward to the next stage. Except, there's one more option. That option is option 3, which is do nothing. Doing nothing is an option. Doing nothing is actually doing something. Doing nothing is actually doing something. It's a choice. I advise clients to do nothing when they have nothing to win or nothing to lose. It could be where the cost of fighting the claim is so small that it's not worth opposing in court or to pay the fees and amounts. Or it could be where the client has no resources to fight with, no money or other assets to come after. Essentially, they are what we call judgment proof. They're uncollectible, even if the person suing gets a judgment from the court. By the way, the legal term for winning when the other side doesn't fight is called a default judgment. Okay, so there are 3 options: motion to dismiss, answer, countersue, and do nothing. If the case hasn't been disposed of or settled by this point, the parties move on to the next stage, known as discovery, getting information from one another, or as it's sometimes said, digging for dirt. And that takes us on to the next stage, discovering information. The discovery phase or stage is where the parties will request information from one another related to the lawsuit. The parties serve requests to one another, and there are 3 basic requests or ways of getting information. 3 basic requests. The first is called interrogatories. It's sending written questions to the other side and requesting written answers back. Now, there are limits to the number of questions that are allowed to be asked, and additional questions can be sent if there is information that is revealed that needs to be followed up on. So it's possible to send a second set of written questions after the first, and a third set of written questions after the second, and so on, as long as they are related to the dispute and not meant to delay or cause problems. The second type of request is called depositions. Depositions are sworn testimony that is taken and transcribed that can be relied upon and used later. The person testifying is swearing under oath that they are telling the truth. Now, it's not an interrogation. It's not related to interrogatories, so don't get confused. Deposition is interviewing a person under oath. Interrogatories are written questions. All right, third type. The third type of request is the request for documents. Now, documents can mean paper documents, but it can also mean digital documents like text messages, emails, voicemail, social media posts, and more. And it can also be used for physical objects or digital objects. As the parties are getting information from one another, it's possible for them to limit or expand the scope of the discovery. They can ask the court to increase or expand the scope because they found information that raised additional questions. Or it could be where they ask the court for protection because one of the parties wants more information than it's entitled to, such as with requesting personal information that's unrelated to the business matter. A scenario like this might come up with employees and BYOD. BYOD is bring your own device, like a smartphone. Some employers have their employees use their own phone for work purposes. If there's a lawsuit against the business, one of the parties may request those electronic records. A request to expand discovery to include that may allow access to private information. The court would have a hearing on that expanding scope of discovery and also on putting limits on what would be allowed as part of that. At some point, discovery ends. No more information is collected, and it moves to the next stage. Remember what I said before. There are three main stages to a lawsuit: pre-trial, trial, and post-trial. We're still in pre-trial. There are two more big stops before we get to the trial. Stop one, a motion for summary judgment, or MSJ. Either or both sides can file a motion for summary judgment with the court. This happens after discovery is completed and before the trial. It is essentially saying that the other side doesn't have enough to win the case. Rule in favor of our side so we don't waste any more of the court's valuable time. A, we have enough information that we agree on. If you believe everything that the other side says, by law we should win. The more official language is, looking at the facts and the law in the most favorable light for the opposing side, we still win as a matter of law. The motion is then going to be opposed by the other side, and the defense is more than likely going to be that there are still facts that aren't agreed upon that should be determined by the court. The court decides on the motion, with or without a hearing. If granted, the party that made the motion wins. They can then enforce the judgment and collect if there are damages to be awarded. Since it's a judgment, the losing party can take it to the Court of Appeals. It works either way. If the motion is denied, then on to the next step. On to trial. Well, almost. Step 2 is the setup for trial. It's the pre-trial conference. Pre-trial conference is where arguments and issues are going to be laid out. It's to clarify misunderstandings, agree on facts that are not in dispute, and identify the real disagreements, as well as a timetable. Which evidence and witnesses will be included and presented to the court. A plan will be put in place as to what is going to happen in court. The court will also try and urge the parties to settle before going to trial. And then, finally, trial. Now, this is going to be an oversimplification, but this is where the parties get to present their cases. This is where both sides have their day in court. They get to tell their stories. The plaintiff, the one who brought the case, has the burden of proving the case, presenting facts and law together to tell a story that is supported by evidence to convince the court, the judge, if it's a bench trial, and the jury, if it's a jury trial, that there was a wrong that needs to be corrected by the judicial system. Legal arguments and theories are offered with the intent to persuade. If the plaintiff meets his or her burden to provide enough credible evidence to satisfy the elements of the laws, then the defendant can provide evidence and arguments to refute the plaintiff's case. The court, the trier of facts, listens and reviews both sides. Once both sides have finished, the court reaches a verdict and provides a judgment. Maybe it's judgment for the plaintiff if the storytelling has been more convincing than the defendant's. Maybe it's judgment for the defendant if the storytelling from the defendant has been more convincing than the plaintiff's. And this has been the culmination of time and energy and effort by both sides to resolve the dispute and get some closure. And even at this point, when one of the parties has quote-unquote won, has gotten a ruling from the court and a judgment, the process still is not done. On the plaintiff's side, even with a judgment, there's more work to do. Just because there's a judgment doesn't mean that there's someone waiting with a check or a money order or a transfer to a bank account. There isn't a wheelbarrow full of money that someone will bring to them. There has to be collection on that judgment. Garnishment, liens, and contempt proceedings may be necessary. Garnishment when the defendant's bank accounts or wages from work can be attached to pay the debt from the judgment. Or liens can be placed on valuable property that is owned by the defendant, such as real estate or vehicles, so that the property can be sold and the proceeds can be applied to pay the debt from the judgment. And if the plaintiff isn't happy with the amount of the award from the court, the plaintiff may ask the court to adjust the award. At the same time, on the defendant's side, the defendant can contest the judgment, asking for the amount of the award to be adjusted down, or to request a new trial if the proper process hasn't been followed or some mistake has happened, and to appeal the case to have it reviewed by a higher court. The case doesn't even have to move forward. It can loop back on itself. If the defendant wins, the plaintiff can also ask for a new trial. In either case, whichever side requests a new trial, the court can review the request and decide if it needs to send the case back for a new trial. That would be unusual, but it happens. And send the proceedings back to the pre-trial stage and then get ready for more storytelling. More time and more resources. Or the court could deny the request for the new trial. Now, this is a visual explanation of the process for a civil trial, and it shows how the parties proceed, the steps that they take, and the paths that they follow. Again, as I said, even if you make your way through all of the different steps, you still aren't done. There's more to this. Lawsuits take time, and there's a cost. It's not like television shows where everything is wrapped up in 45 minutes and there's a happily ever after. Now, I'm not going to give you an explanation of criminal procedure, but I have included a small diagram that you can review. The only takeaway that I want you to be aware of is that there's a cost on the criminal side. Time and money that can be better spent elsewhere. It's good to be aware of what laws affect your business and then not to run afoul of them. I'm also not going to give you any more explanation of the appeals process than we have already done. I've included a small diagram that dovetails onto the Chutes and Lawyers materials, with the appellate courts reviewing cases, not like a trial, with new evidence, but looking to see that the lower court followed a procedure and applied the law to the facts properly. And with the Supreme Court reviewing the process if necessary.